Section 3, Legal Hotline Q&A on Advertising, Arizona Market Introduction. Advertising looks easy until it isn't. In Section 2, we discussed good real estate practice in the Arizona market, especially how advertising must be clear, accurate, and not misleading. Now we take that rulebook and put it into real-life situations. Advertising is no longer just a yard sign or newspaper ad. Today, it includes websites, social media posts, videos, email blasts, AI images, flyers, open house promotions, billboards, and even We Buy Houses signs. The 2025 ADRE rule updates specifically modernize advertising rules involving electronic media, AI, and property renderings. The main rule is simple. The public must not be confused about who is advertising, whether a licensee is involved, what brokerage is responsible, or what is actually being offered. Question 1. Does a for sale sign need the broker's phone number? An Arizona licensee wants to place a custom sign on vacant land. The sign includes the brokerage name and the licensee's information, but only the licensee's phone number. Does the sign also need the brokerage phone number? The answer is no. The brokerage phone number is not required. However, the brokerage name must be clear and prominent. AAC R4-28-502 requires advertising to be accurate and not misleading, and the employing broker's legal name or licensed DBA must appear clearly in the advertisement. Best practice: the broker name must be easy to see. The phone number may be the agent's number, but the public must know which brokerage is involved. Question 2. Can a team run a drawing for a gift card? A team wants to enter people into a drawing for a $250 gift card if they like the team's Facebook page or attend an open house. Is that allowed? The answer is no, or at least highly risky. ARS Section 32-2153 allows discipline when a licensee solicits prospects through a speculative promotion involving a game of chance, lottery, or contest. The concern is that requiring someone to attend an open house or like a page in exchange for a chance to win something may look like a game of chance or gambling. Best practice: avoid drawings, lotteries, and chance-based contests connected to real estate marketing. Question 3. Can real estate providers jointly market an event? A broker wants to co-sponsor a commercial open house with a title company, lender, and mobile home manufacturer. Is joint advertising allowed? Generally, yes. Joint marketing is not automatically a RESPA violation. The key issue is whether each party pays their fair pro rata share and receives fair visibility. If the lender or title company pays most of the cost while the broker receives most of the benefit, that can create a RESPA concern. But if all parties share expenses fairly and are equally represented, the risk is much lower. Best practice: document the cost-sharing arrangements and make sure each sponsor pays their fair share. Question 4. Can an investor billboard route calls to a broker? A private investor wants a billboard that says, "We'll buy your home for cash," with the phone number going directly to a broker. The billboard does not identify the brokerage. Is that a problem? Yes. If the billboard is connected to a broker or licensee activity, it must not hide the fact that a licensee or brokerage is involved. Advertising must identify the employing broker clearly and prominently. Best practice: if a broker is involved, do not make the advertisement look like a private, unlicensed transaction. Question 5. Can a licensee use We Buy Houses signs? A licensed agent wants to put up We Buy Houses signs while acting personally, not through the brokerage. The signs do not disclose that the person is licensed. This is risky. Even if the licensee is acting personally, failing to disclose license status may mislead the public. The safer practice is to disclose that the person is a real estate licensee and avoid creating the impression that no licensee is involved. Best practice: if you are licensed, do not hide it. Question 6. Can a broker pay a referral fee to a non-licensee? A broker wants to offer a $50 reward or 1 month of free property management services to a non-licensee for referring a new client. Is that allowed? No. Arizona Revised Statute Section 32-2155 prohibits paying compensation to an unlicensed person for activity requiring a real estate license. A referral fee tied to producing a client can create a violation. A small gift that is not contingent on a referral may be allowed as a marketing expense, but it cannot be payment for producing real estate business. Question 7. Can a broker offer a gift at closing? A broker advertises that if a seller lists with the broker, the seller will receive $1,000 worth of boat services at closing. Is that allowed? Generally, yes, if the offer is clear, truthful, and not misleading. A licensee may advertise a gift or incentive at closing if hired by the client, but the terms and conditions must be specific. Best practice: say exactly what the client receives, when they receive it, and what conditions apply. Question 8. Does the brokerage name have to be the largest item? No. The brokerage name does not have to be the largest item in the advertisement. However, it must be clear and prominent. That means it cannot be hidden in tiny print, buried at the bottom, or hard to read on a social media graphic. Closing thought. Advertising compliance is really about public clarity. If the public can tell who is advertising, which broker is responsible, whether a licensee is involved, and what is actually being offered, the advertisement is usually on safer ground. If the ad creates confusion, hides important facts, or uses chance-based incentives, it may create legal trouble before the first phone call even comes in. Online discussion. Question 1. Why is it risky for a licensee to advertise "We buy houses" without disclosing license status? Answer. Because the public may believe they are dealing with an unlicensed private buyer when a real estate licensee is actually involved. Question 2. Why are drawings or contests risky in real estate advertising? Answer. Because they may be considered games of chance, lotteries, or speculative promotions, which can violate Arizona law. Question 3. What is the safest way to advertise a gift or incentive at closing? Answer. Clearly state the gift, the conditions, when it will be provided, and avoid misleading impressions.